All rise. The Minnesota Workers' Compensation Court of Appeals is now in session. Chief Judge Yoel presiding.
Thank you. You may be seated. I understand we have some technical difficulties today with the microphone, so we will make sure that we speak loud and clear. Well, good morning. Today's July 20th, 2026. It should be live stream. Eventually it may be. An oral argument is recorded and the link hopefully will be on the WCCA website. We're here today on one case, WID 195-17787. We're here on an order denying the Special Compensation Fund's petition for contribution and dismissing ME Roofing and the Minnesota Assigned Risk Plan as parties to the proceeding. I have here as the appellant with the Special Compensation Fund, Yoel. Thank you. Did I say it correctly? Thank you. I also have Christine Tuff representing ME Roofing and Minnesota Assigned Risk Plan. I note that the employee, Edin Yoel Peralta-Hernandez, is not present, and neither is the attorney representing the employee, Vincent Peterson. Peralta-Hernandez versus Pahl Exteriors LLC, uninsured. James Pahl, uninsured, correct? Thank you. Francesco Garcia Sr. and Francesco Garcia Jr. are also listed on the caption as employers, and they are uninsured, correct? And I note that I do not have either Senior Garcia or Junior here today. Is that correct?
Your Honor, my understanding is that they are the owners of the ME Roofing who is insured.
I'm sorry, can you?
Francisco Jr. and Senior, they're the owners, operators
Okay.
of the company called ME Roofing who is insured.
Okay, so they own ME Roofing?
Yes.
Okay, thank you. I'm Patricia Millen, the Chief Judge of the WCCA. This is a full court panel today, and I identify the members of the court as follows. Judge Sundquist is on my far left, Judge Christensen, Judge Quinn, and Judge Carlson. Each of you will have 15 minutes to present your opening statement. We will allow uninterrupted time. At the 3-minute mark, I will stop and see if my colleagues have any questions that they'd like to move forward. You are welcome to reserve time. I don't know if the questions will exceed that or not. We'll make sure that everybody has an opportunity to be heard. If there's no further questions or issues for what I've just stated, we'll go ahead and go forward. Attorney Yelokoff, why don't you begin?
Thank you, Your Honor. May I please the court, counsel? My name is Yuri Jolikov. I'm with the Department of Labor and Industry, appearing on the special on behalf of the Special Compensation Fund on a decision we received in a case where the claim petition is still pending, and we have not yet had a chance to have our evidentiary hearing. This case involves one date of injury, a single traumatic event where the employee unfortunately fell to the ground during the roofing project. This case does not involve any claims for occupational disease or asbestos exposure or multiple dates of injury with multiple insurers. This case does involve two alleged employers, and there is a dispute about which party was the employee's actual employer at the time of the injury. And there's also a question whether we're dealing with joint employment situation or not. We are appealing the compensation judge's decision dismissing ME Roofing and denying the Special Compensation Fund's petition for reimbursement against ME Roofing. And we are asking this court to reverse that decision in its entirety and also make a determination that the parentage settlements are not proper and should not be used in cases like this one. It is our position that the way the parentage settlement was applied in this case is inconsistent with the underlying principle of parentage releases, which requires that the settlement agreement does not prejudice the rights of the non-settling parties and does not shift liabilities and burdens of proof to the parties not otherwise liable for benefits. It is also our position that the compensation judge's decision is inconsistent with the Minnesota Supreme Court's decision in Sershin versus Metropolitan Council, where the court stated that the issue of whether the non-settling party has a right to be reimbursed by the settling party must be determined by the compensation judge, because otherwise the non-settling party is improperly prejudiced by cutting off its statutory right for reimbursement. And finally, it's our position that the order that we're appealing today is inconsistent with the Workers' Compensation Act as a whole, because it was issued as a summary judgment, which is not something that's provided for under the statute. And the decision is also inconsistent with 176.322 and the case law that interpreted it that require evidentiary hearing in cases involving factual disputes. And it also does not authorize release of the parties over the other parties' objections.
Thank you. I'm going to stop you and look to my colleagues and see if there are any questions.
Thank you. Council, first of all, I want to talk about the concept of the parentage release. You've invited us to make a decision where we would say parenters are not appropriate. I think you're saying in work comp in general, or when the special compensation fund is involved. Do we really need to decide that in this case? Isn't the issue simply whether the judge erred in not granting your petition for contribution? Do we really need to tackle the parentage issue here?
The issue, well, obviously there are two issues, and thank you for the question, Your Honor. We have two issues. Number one is that the denial of the fund's petition for reimbursement. Obviously, that needs to be addressed by the judge, and we do need to have an evidentiary hearing in order to do that. And as a part of the evidentiary hearing, one of the parties, which is usually the employee, has a burden of proving the employment relationship. And with ME Roofing absent as a party in that hearing, the compensation judges cannot make a binding decision against the ME Roofing with regard to them being employer or not.
But counsel, the cases are settled all the time before the employee establishes their burden of proof. I mean, it happens all the time. So what is different about this case?
The difference is, let's say we have a settlement with one employer and a claim against another employer. In that case, we are not taking away the right of joining the settling party as a necessary party to the settlement. The statute provides for joinder of parties. We are not prejudiced in terms of conducting full discovery as the rules allow. We are not precluded from seeking sanctions under the discovery rules against the parties to the case. And when the party is taken out of the case, we can't do anything against that party other than change the venue and switch our discovery process to the district court.
Okay, and I'm going to let my colleagues address some of the discovery issues. But let me ask you this. In your statement of facts, you indicated in your original answer that you indicated there was an argument of joint employment.
Yes.
And you said that today here in your opening.
Yes.
And I agree with you that a joint employment situation would make us look at this in a different way than if there's no joint employment situation. But you were allowed to present evidence at the motion hearing. Was there any evidence of a joint employment relationship?
We didn't get to that argument at the motion hearing because we were under the impression that we will have that opportunity to present that evidence and arguments at the full evidentiary hearing. So it was a purely motion hearing that was set in response to the insurer's comment in their answer to the petition for reimbursement that they're asking to be dismissed. And our argument at that time was the dismissal was not appropriate because we have multiple issues of material fact, including the employment situation. And specifically joint employment, I don't believe it was brought up. The issue of who's the employer was at the time of the injury is the pivotal question in this case.
Okay, thank you.
So I'm curious about that. Let me confirm something though. Pahl is the general contractor, Emmy is the sub, correct?
Yes, Paul is,
Yeah.
found the client, pulled the permit, hired the sub
Okay.
hired.
All right, so if it was reversed, we might have a totally different scenario here,
Correct.
but that's not the case here. And the fund has not paid one penny on this claim yet, correct?
Not yet. Yes.
Okay. All right, so under scenario one, Emmy is the employer and Paul is not. If that's the way the finding is, the fund never pays anything, correct? If there's a finding that Emmy is the employer, the fund is never going to be liable, correct?
That is correct.
All right.
We will have the insured employer situation.
Right.
Yes.
And if it's the other way around, Paul's the employer and Emmy is not, then the fund has to pay. And if that's the case, you're not harmed by the settlement.
Unless we can show we have joint employment.
Okay, so then the third scenario is joint employment.
Yes.
Okay, so, and the burden of proving any employment relationship is on the employee, correct?
Correct.
All right, and if it stays as it is, the employee is going to try to prove that Paul is the employer and Emmy is not.
Correct, exactly.
Okay. All right, and from what we have been able to see in the record so far, there's not a whole lot of evidence that Paul is the employer.
That is correct, and that's what's puzzling. Is
Right.
Why we're here.
So just from, I'm just curious about this. Why would you want Ms. Tuft in the courtroom at all to try to prove that Paul is the employer?
Well, because we have to do our due diligence.
Okay.
And we do need to conduct our discovery
Okay.
appropriately and make sure.
But you've taken the discovery from the employee, and I'm sure you've asked, what evidence do you have that Paul is the employer?
We did conduct a discovery deposition of the employee. We were unable to depose the representatives of Emmy Roofing. Correct.
Of Emmy Roofing, but you have Mr. Paul saying, I'm not the employer. You have the employee saying, I really don't know.
Yes, and we have employees counsel claiming Paul is the employer. So
Yeah, so, okay,
they
all
have to
right.
defend.
So why is ME a necessary party, just as a party to get to that burden of proof level? I get the discovery issues and I can't enforce discovery mechanisms if they're not a party, but you don't need Emmy in the courtroom to prove that, do you?
Well,
Or the
again-
employee does, maybe, but you don't.
Again, we're dealing with the shifting of the burden of proof from the employee to the fund. That's obviously not how it should be. And number two, we should probably be looking at things from the employee's perspective. And obviously I don't represent the employee, but in this situation, if we can show that the employee was not comprehending the stipulation for settlement or disagreed with the language where he took on the responsibility to be responsible for reimbursing the fund, should the fund be found liable, Our position is that the most likely the employee will disagree with that agreement under the stipulation, and we're probably going to be dealing with the mutual mistake of fact potentially.
Okay, but those are all after the fact kind of scenarios. And, you know, this court recently issued a decision about a year ago. The name of the case was Mike versus the name, I forget the other side party, but, and where we said, you know, you cannot take away an obligation through settlement of the employer to the employee.
Correct.
Okay. Arguably, that same kind of thing applies to your statutory right to contribution. But
Correct.
we're not, but we have to get there. We're not there where the fund actually has paid money and ME should have.
Again, from my perspective, the ME Roofing should want to be a party to this case because, you know, obviously, if we can establish the employee's disagreement with a stipulation, that potentially puts the stipulation in jeopardy. So they should be given opportunity to question that. We also need them, again, from the discovery perspective, and also for our claim that we haven't brought yet in this case, because again, we haven't had a chance at the hearing, that parent-juror settlements as a whole are not appropriate for the case like this, because not only they prejudice the parties in a workers' compensation setting, but for example, let's take a look at Medicare. Let's say down the road, Medicare steps in and they have a federally statutory right to claim reimbursement against of any medical benefits they paid on the case. Under the terms of this parent-juror settlement, ME Roofing is scot-free clean, and it's the employee who is stuck with dealing with reimbursement. Obviously, that's probably not a valid portion of the settlement, but that's something that we still would like the court to address and contend with. And I believe ME Roofing would have a very strong opinion to express, during that argument.
I'm going to turn to my
Yeah.
colleague. Thank
Yeah,
you.
I have a question. There's, the employee is not here, nor is the employee's counsel here today. And I haven't seen, they didn't brief anything. Is there something that I'm missing where the employee is now attempting to vacate this settlement that was reached because we haven't received any supplementary pleading or petition by the employee to vacate? Is that just an argument you're making, or is that actually a position the employee is taking that you're aware of?
I can't speak for the employee. Obviously, I don't know why they're not here today. Other than the letter brief that they filed with this court, I have not had any further.
And would you agree with me, the settlement agreement is between ME Roofing and the employee and the insurer of ME Roofing, and those are the parties to that stipulation for settlement and award, and at least this court has said those are the only parties to the settlement are the people who can bring a petition to vacate. So you can't, nor Mr. Pahl, would you agree that neither you nor Mr. Pahl or the Garcias personally can bring any petition to vacate the settlement as exists?
Yes, at this point, that is absolutely correct. We do not meet any of the 4 criteria for vacation of the award. However, our position is that this is stipulation and award that are voidable. And if they contain the language or the stipulation that are not consistent with the statute, I think this court has already ruled that it has an opportunity and option to avoid the settlement if it's in conflict with the statute. And I do have a citation actually for that case. It's Larry Sandroll versus Del Heiss, 47 WCD 659. where the court has discussed the avoiding of the settlement, stipulations for settlement that are not in accord with the statute.
All right, it looks like you're out of time, but I'm going to ask you some questions, Mr. Yurk.
All right.
All right. Is this a true Perringer settlement? The language is hold harmless here. Is it necessary that that language also includes indemnify and defend language?
I think this is the language where the whole appeal is revolving around because of that language, ME Roofing was dismissed from our petition for contribution. So in a pure sense, it is a Perringer settlement. We're not disputing that. Our argument is that it does not belong in a case like this.
All right, then I'd like to follow up with that. All right, so what we're dealing with today is just the judge's order dismissing your petition for contribution reimbursement against ME. All right, where's the harm? Where's your harm here? I don't see any harm to that order. Because I'll tell you why. You will proceed to a trial, and in any other situation involving a Perringer release where you have a settling and non-settling party, the non-settling party goes to trial. The judge or jury determines responsibility among the remaining parties and also the settling party, and then there's an allocation, right? So that's typically what happens. In this situation, you will be in a trial, right? The judge will determine who is the employer. What I don't understand here is, how is this harmful to you? How is this harmful to the Special Compensation Fund, this order?
Well, essentially, when we go to that trial, if everything stands the same and ME Roofing is still not a party, we go into the fight with our hands tied behind our back. We can't do discovery. We can't.
Yeah, but you can do a deposition. You can subpoena. There are other options available for you that are not included in formal discovery.
Again, those are the options that are available. They're not reasonable in this case because the Special Compensation Fund, I can't represent the fund in that kind of discovery. We have to refer matters to the Office of AGO's office, Attorney General's office. And it's simply not practical for them to take over the discovery depositions or motions. And the bottom line is that we are given certain rights under the discovery provisions. We are authorized to seek sanctions for the parties who do not comply or choose not to participate in the case.
How is that any different, though? How is this case any different than a standard Perringer situation where you have a settling, non-settling party that goes to trial? How is this case different?
I do not believe the Perringer settlement situation has been thoroughly addressed by the courts in terms of whether it's appropriate for the procedure we have outlined in the workers' compensation system. And that's what we're doing here today, is trying to get the court's attention to the difficulties we have to endure as the party who got settled around. And now we are having our rights taken away by the parties who agreed to settle amongst themselves.
Okay, thank you, Mr.
All right,
Jacob.
but I want to just follow up on that though, real quick. The burden of proof is still on the employee. You don't have to prove that ME is the employer. The employee has to prove that Pahl is the employer for the employee to win. If they can't, you're out. You're acting as if you have a burden of proving something, and I don't think you do.
Our burden of proof is to show that Pahl is not the employer.
That's not even your burden of proof. The burden of proof is on the employee to prove Pahl is the employer. You can poke holes in that, but you don't have to prove that they're not.
But at the same time, if we have a dispute about who the employer was at the time of the injury, it's our burden to show, to say, hey, it's not this employer, it's that employer.
And you must have that evidence because you told the employee when he first filed the claim petition just against Pahl, look at ME, and the employee said, oh yeah. And they amended their claim petition. ME was satisfied enough to throw not an insignificant amount of money towards the employee. It must be pretty compelling evidence.
The only evidence of the employment relationship that we have, like a solid evidence, is the deposition of the employee. He was a cash employee. There is really no paper trail connecting him to any of the employers.
Then you win.
Ostensibly.
Not necessarily. I disagree with my colleague, and I don't want to move
Okay.
past 6 minutes beyond the 15.
Okay, I just,
But I do say this, a joint or shared employee is a burden that the Special Compensation Fund explores uniquely, correct?
That is correct. That
Because the liability can shift, and there can be penalties, and there can be other issues that only the Special Compensation Fund would monitor and address, correct?
that is correct.
Thank you. I have nothing further.
Good.
I have a question. You can't penalize or go after ME Roofing for any of the normal things because ME Roofing was insured at the time of this injury. So the normal things, a 65% penalty, your attorney's fees, costs, and things like that. You can't pursue them for that. Is that correct?
Correct.
Okay.
The only thing we're asking is for them to be available so we can present our case at the time of the evidentiary hearing. In that case, it would be nothing different from them settling separately without the parenture and us pursuing the defense against the employee and adding them as a joinder, but they would be insulated by the settlement.
Thank you. Anything further?
Nothing further.
Okay, you may take a seat. We have an additional 7 minutes. Ms. Tuft, thank you.
Good morning, Council, Mr. Pahl. May it please the court. My name is Christine Tuft, and I represent the respondents in this matter, ME Roofing and the Workers' Compensation Assigned Risk Plan as administered by Superior Point. It is the position of my clients that the compensation judge had the authority to and correctly denied the petition for reimbursement of the Special Compensation Fund and correctly dismissed my clients from the ongoing litigation. Why? Because the claimant and my clients entered into a valid Parenger type settlement agreement, which was approved by the CAH, wherein the employee settled his claims with my clients on a full, final, and complete basis, including future medical, and agreed to hold my clients harmless from any claim which could be brought by any other parties. So we respectfully request that this court approve or affirm the order denying the petition for reimbursement and dismissing my clients. Now, in its notice of appeal, the Special Compensation Fund raised 2 issues. The first issue was the procedural issue. Was the on-the-record hearing on the objection to the petition for reimbursement an appropriate way to handle the procedural issue in this matter? The answer is yes. The Special Compensation Fund, I think, conflates the issue of a hearing on the merits of the claim petition with a hearing on the motion, essentially the objection to the petition for reimbursement. The Special Compensation Fund did not attach anything to its petition for reimbursement. It hasn't paid anything in this matter, so there's nothing to attach. They didn't submit any exhibits at the motion hearing. They weren't prohibited from submitting any exhibits at the motion hearing. And they're primarily making some different arguments now than they made at the motion hearing, if you read the transcript. But they never asked for a full evidentiary hearing on the motion either, which is what they asked for the first time at the appellate level. So from our perspective, the procedural issue was handled correctly, and the motion or the petition for reimbursement was correctly denied. The second issue raised in their notice of appeal was whether Parenger type settlements are appropriate in the workers' compensation system. And there's various parts of this argument that have kind of come and gone in the various briefs that were filed by the Special Comp Fund and how they worded that issue in their notice of appeal. But as a succinct way of answering that question, our position is that yes, Parenter type settlements are appropriate in the workers' compensation system. They don't need any limitations, as is suggested in one of the briefs of the Special Comp Fund. To certain circumstances, the Special Comp Fund should not be allowed to prohibit Parenter type settlements in any cases.
Okay, I'm
in
going
which
to
it's
interrupt you
involved.
there with that last thought. Thank you.
Thank you.
And turn to my colleagues. Judge,
Good morning.
Good morning.
Ms. Tuff, I'm going to hop right into the concept of a parenter again. And again, the concept of a parenter is when there's going to be a fact finder, a jury making a decision on a comparative fault type of basis. And in non-work comp matters, it can be appropriate unless there's some type of a joint and several liability. So even assuming that that would apply to workers' compensation, again, this is not the type of case where there is comparative fault, right?
Correct.
And if there were a finding of joint employment or joint liability, then would you agree that a parenter would not be appropriate in that type of a situation?
Not necessarily, Your Honor, because again, the concept behind a parenter settlement is, as you said, when it started in the civil realm, to look at that comparative fault type scenario. But even in a joint employment situation in workers' compensation, one party can be held completely responsible. There doesn't have to be a divvying up of comparative liability. So I don't think that joint employment scenarios should be held out to not allow parenter
Okay,
agreements.
so then that gives me two questions. First of all, do we really need, and the same question that I asked your opposing counsel, do we really need to decide the issue of whether a parenter is appropriate in work comp, or do we just need to decide whether the compensation judge was correct in denying the petition for contribution?
Your Honor, I don't think you need to decide whether a parenter is appropriate in workers' compensation as it relates to this particular case. And in fact, it wasn't even raised as an argument at the original motion hearing either. But no, I don't think it's necessary to a determination of the issues in this case.
And assuming then that the employee goes forward against the special compensation fund, the special compensation fund would still be able to claim there's it's a joint employment situation. Would you agree with that?
Correct. It
Okay.
would be up to the employee to argue.
But
for
if there was a finding of a joint employment situation, what would the special compensation fund's remedy then be against your client?
They would not have a remedy against ME Roofing. Their remedy would be, well, they arguably could have an argument for a claim against ME Roofing, but it would be then handled by the settlement that ME Roofing has with the employee, in which the employee agrees to hold them harmless.
But isn't that more of a collection issue as opposed to who is liable under the statute?
Well, it would depend on if the special comp fund paid anything. I mean, at this point, they haven't paid anything. We don't know what they might be
Sure,
ordered to
yep,
be
and I'm
paid.
assuming a finding of joint employment. So there's a finding of joint employment, and wouldn't the statute then say that because there's an uninsured employer, that your client is liable?
That involves having to prove that there's a subcontractor, a legitimate subcontractor arrangement, all of those pieces to get to that joint employment, none of which we have here, none of which we have evidence
Well,
to
and that-
establish here. And
But that gets to Mr. Jellikov's point. It makes sense to flesh out those factual issues on the front end as opposed to after a settlement.
I can understand that argument, but we didn't settle this 15 days after the amended claim petition brought our clients in to this matter. I mean, I think that timeline is important if we're going to get into, opportunities for discovery and things like that. The amended claim petition bringing my clients in was over a year prior to the finalization of settlement agreement in this matter. So there has been plenty of time to conduct discovery.
And that brings me to my last question. Do you find any merit to the argument that your client should be kept in as a party in anticipation of discovery trouble for Mr. Jelikoff and Special Compensation Fund?
Absolutely not, Your Honor. Again, we had a long period of time during which discovery could be conducted in this matter, and there were no discovery motions filed during that time frame. And my client should not be required to continue to pay for the cost of litigation that they have been dismissed from twice.
Thank you.
But how is he going, let's say Mr. Jelikoff says, all right, I lost at the Court of Appeals. I'm gonna try to get the Garcia's testimony. I'm gonna try to get documents from ME Roofing. He serves discovery in some fashion through a subpoena. Is he gonna get it?
Well, it's not in the record, Your Honor, but the deposition of the Garcias, I believe Garcia Senior was scheduled, and I did advise Mr. Jelikoff twice that we could not locate Mr. Garcia. So the deposition was canceled.
Right, that was
So
referenced
those
in the brief, I
efforts-
think. Yeah.
Yes, thank you.
But, all right, so it may be impossible to depose them anyway.
Correct.
Okay. More importantly, so the petition was to join your client as a party, seek contribution for
Well,
nothing at the moment.
Could I just,
Sure.
there is no petition for joinder.
Okay,
Well,
right,
I mean,
yeah,
procedurally,
right.
this is very odd.
Right, and that's,
So-
and I agree with you. If it had been a petition for joinder, it'd make it a lot easier. But it's a petition for contribution, and there's nothing to contribute to because there was no payment made.
For reimbursement,
Yeah, okay,
actually.
yeah,
Sorry,
yeah.
I don't mean to
Okay, even
correct you,
better,
but
even better,
I mean,
reimbursement.
procedurally, it's very strange here, so.
But let's assume it was a petition for joinder just for the sake of the argument. The settlement agreement between your client and the employee says the employee agrees to indemnify your client, pay any benefits that your client might be held liable
Mhm.
for, arguably to the fund, because I can't imagine any other party it would be. It doesn't say your client, or that the employee agrees to defend your client. A lot of agreements have, defend and indemnify. This is just indemnify.
Mhm.
So I don't see why, again, let's assume it's a joinder. I don't see why your client can't be a party. I can see why your client would say, we don't have to pay anything. If we're ever found liable, we turn to the employee for that. But being a party,
Well, being a party to a claim assumes that there is something that could be awarded against the party. This argument that my client should be a party here is just for form, I guess, if anything, because I believe that based on arguments I just heard, everyone agrees that ME couldn't be held liable for any payment of anything under the current scenario. And so
well, it could be. Your client could be held liable, but then your client then pulls out the settlement agreement and says indemnifies.
correct,
So-
they couldn't have to pay.
Right. So
So
that's, I realize it's a lot of form over, reality and function stuff here. But your client being a party versus your client paying money to the fund seemingly are slightly different things.
and I understand where you're going, Judge Quinn, but I haven't, I will admit, thought about the definition of what it means to be a party to a matter, but certainly if, let's just take it to a different hypothetical, if my client, if there's a claim petition alleging that ME Roofing is the employer in a case, and I contact the plaintiff's attorney and I say, hey, you've got the wrong name. ME Roofing is not the employer in this matter. I think your guys' employer was BE Roofing. My clients wouldn't have to remain a party to that matter when it's already been shown that they can't be held responsible for any payment in that matter. And that's essentially the scenario that we have here. ME Roofing can't be held responsible for any payment in this matter.
Thank you.
And my question deals with the discovery. When ME was a party, I have he responded to, I think, discovery from the employee on answering 7 questions on September 26, 2024. So at least to that extent, discovery was responded to by your client. And then it sounds like the depositions were attempted to be scheduled of Garcia Senior and Junior, and they could not be found. Is correct understanding on my part?
Yes, Your Honor.
And at least from looking at the deposition that Mr. Pahl gave some time ago, he essentially is saying he's a sole proprietor, doesn't need work comp because he's a sole proprietor. Is that, fair understanding on my part of his defense?
Fair understanding, no argument of joint employment.
And so, when coming back to the joint employment beginning, there's no evidence before us that, well, as you can tell me, of any allegation made by the employee, before you were settled your case of joint employment in this case.
Correct. It's really a new allegation here. I think that there's an argument for joint employment. The employee certainly has never submitted anything that I've seen that makes an argument for joint employment.
And in his deposition, there were friends, a friend who paid a friend who paid a friend who paid him.
Correct. That was
It
his
was cash.
testimony. Cash, yes. That was his testimony.
Anything else, Tom?
Go ahead.
Ms. Tuff? Could we decide this case simply on the fact that the petition for reimbursement wasn't ripe?
Yes, you could, Your Honor.
Because-
Arguably a petition for reimbursement isn't even accurately filed because there's nothing attached to it.
Right, and even the order, the first paragraph talks about benefits the employee may be deemed entitled. So we're not, it seems to me that this is not a case that's ripe for any kind of contribution claim, right? So alone, that issue alone, we can decide this, correct?
Correct. I actually have it in my notes, what I call it a phantom petition for reimbursement because nothing has been paid and we don't know that anything will be ordered to be paid.
Thank you. Thank you. I have another question, and that concerns how this case is different from the standard comparative fault cases. And I know Judge Carlson and Judge Quinn talked a little bit about it, but I need to get your perspective on Mr. Yelikoff's argument on the joint employment piece being different than a comparative fault type of situation in typical civil cases. Could you comment on that?
You're asking me whether I think it's different from a civil comparative fault
Yes.
analysis. Well, it's been a long time since I've been in district court, I will admit to all of you. But as I understand the comparative fault analysis versus the joint employment analysis, we're talking about two completely different standards. Number one, so to establish the joint employment scenario is a completely different set of factors that is looked at versus whether two other parties in a district court matter may each have contributed to or been at fault for something that occurred. Whereas joint employment is really looking at the relationship between the parties versus the fault as between the parties.
All right. Thank you. No more questions.
Good.
Any more? Any more questions?
Nope.
Nope.
No. Thank you.
Thank you.
I believe the record is closed. Thank you both very much. Decision will be issued within 90 days. Everybody have a good day.